Hello, my name is Edward Gross. I am the managing partner of the law firm of Gross & Romanick. We are located in Fairfax, Virginia. I am going to discuss non-compete agreements in Virginia. There are numerous types of restrictive covenants commonly found in employment agreements. The restrictions may include covenants not to compete, non-solicitation of customers and prospects, non-solicitation of employees, non-disclosure of confidential information, and trade secret protection. This video will concentrate on covenants not to compete and will be limited to employment agreements in Virginia. I'm going to keep the discussion simple, but this is a very complex area, and if you have a specific issue, you should consult with an experienced employment lawyer. Many people believe that non-compete agreements are not enforceable in Virginia. That blatant statement is simply not true. However, the courts do not favor non-compete agreements and will not rewrite a poorly drafted agreement to make it enforceable, a practice which is called blue lining. A blanket provision that an employee cannot work for a competing business will not be enforced. The language must be narrowly drafted in the employment agreement to prevent the employee from actually providing competitive services, not just working for a competitor. In order for a written non-compete agreement to have a chance of being enforced, its restrictions must be narrowly tailored to protect the legitimate interests of the business. But at the same time, it cannot be unduly burdensome as to prevent the former employee from obtaining employment, even in the same type of business as the former employer. The court will look at the reasonableness of the competing restrictions. Here are the major issues reviewed by the courts. Time. How long are the contacts and secrets usable by the former employee? 1 or 2 years generally will work, but there is no hard and fast rule. Geography. What is the actual reach of the business being protected? If it is a local store, then the reach may not be very distant. It could be a few miles, it could even be a few blocks. But if it is a multinational enterprise, the reach might be global. What are the legitimate interests of the business being protected? Restrictions that generally upheld can include reasonable restrictions on the ex-employee from working on the same or follow-on contracts which were part of the duties while an employee for the company. Restrictions from becoming employed by the specific governmental agency, division of that agency, or customers for whom the employee worked while as an employee of the company. This is termed a non-solicitation provision. Or providing to a competitor enterprise information which could have only been learned as an employee of the company being protected. I've already discussed non-solicitation provisions, which restrict a former employee from soliciting customers of a former employer. Other non-solicitation provisions can include restrictions on recruiting other employees or independent contractors from leaving the employer or working with a competitor. The enforceability of non-solicitation, non-recruitment clauses are similar to the analysis of the covenants not to compete. However, courts are more likely to enforce these reasonable provisions if limited to protecting the company with minimal restrictions on the employee. I hope that this discussion was useful. If you want to learn more about this topic, other business topics, legal topics, visit our website at www.gross.com or call us 703-273-1400.